Also call the case.
Good morning, Your Honors. The matter before the court this morning is the case entitled Kevin Barrup v. Barrup Farms, Inc. et al., case number 24AP248. Representing the appellant, Kevin Barrup, is attorney Harold Stevens. Representing the appellees, Barrup Farms, Inc. and Rodney Barrup, is attorney Susan Flynn.
Thanks very much. Before we start, I've had some connectivity problems off and on over the last week or so. So if I have to, I'll turn my video off. And if it gets to be more than that, I'll let you know so that we can interrupt the hearing and I can reconnect somehow by phone probably. But anyway, just as a word of note before we start. So let's start obviously with the counsel for the appellant. Please, for the record, introduce yourself, identify your client, and then proceed.
Good morning, Your Honors. Harold Stevens for the appellant, Kevin Barrup.
Thank you. Yes, please. Thank you.
So basically, I know it's very difficult on appeal to overturn a jury verdict, but if there's ever such a case, this is one. First of all, the jury didn't properly answer their interrogatories. Question number one was to be answered before you went to question number two. They never answered question number one and went to question number two. So,
Mr. Stevens, couldn't the trial court at that time, when it reviewed the interrogatories from the jury, sent the jury back to answer question number one?
that's what they should have done. It
Well,
didn't
that
happen.
wasn't requested, was it?
I don't see it in the record, but the point is that that's the only. I don't know that the parties have to bring that to the judge's attention. The judge is running the trial and should make sure that the interrogatories are properly answered. And Rule 49B makes it clear that that's the only thing the judge can do is really return it to the jury, which he didn't do. So that's number one on our appeal. Number two is more importantly is that this jury apparently got impassioned by Attorney Flynn's incredible seething cross-examination of Kevin Barrup, which made him out as a bad character, a liar, and all other sorts of things. But in point in fact, even if any of this was true, it didn't cause any problems with the delay in the sale of the property, because one of the main conditions in the sales contract was that they had to get a clearance letter called a SMAC letter from A&R about an oil tank from 2019. Even earlier, and that had to be cleared before they closed. So basically, the delay in closing was not caused by any of my client's actions, but more so by the requirement for the SMAC letter.
Mr. Stevens, isn't there an ethical obligation for an attorney, especially when an opposing party is on the stand, to have vigorous cross-examination?
I'm not criticizing Attorney Flynn. If I'm criticizing anybody, it might have been the attorney that was representing the client at the time. I wouldn't have allowed it personally. But in any event, it appears that the jury is more impassioned. The clear facts are that this sale was delayed. The only reason the sale was delayed for a couple of months was due to the need for this clearance letter that the oil tank, underground storage tank, had been properly removed and remediated. And that's no dispute of fact. So basically, the contract went through. Mr. Barrup Sr. got his money. There was no showing that there was any loss whatsoever. So I'm going to reserve a couple of minutes. Thank you.
Okay. Thanks very much. We'll turn to the counsel for the appellee. Please introduce yourself, identify your client, and then proceed.
Good morning, Your Honors. My name is Susan Flynn. I represent the appellees in this case, Rodney Barrup and Barrup Farms, Inc. May it please the court. I think it's clear, talking first to the issue about the juror questionnaire, that the jurors were smarter than the attorneys in this case, because by answering question 2, they obviated the need to answer question 1. And frankly, had they answered question 1 inconsistent with question 2, it would have only caused real confusion. And
The
so,
only inconsistency, Ms. Flynn, the only inconsistency on answering question number 1 would be if the jury checked no. That would be the only way it could be inconsistent, correct?
exactly. And if they checked no, right, that would be inconsistent with their decision that in fact the evidence showed that Kevin Barrup interfered with the sale, which substantially affected its value. So having found that, there really was no need to answer question 1, or to your point, Your Honor, to do so would have created inconsistency. Yeah, we should have caught that. Honestly, we should have caught that going in because of the potential for inconsistency, but the way the jury ruled created no inconsistency. And so
Was the judge obligated? Do you think the judge was obligated to send them back and say, "Hey, we need something in question number 1," or we could just presume that question number 1 would be a yes?
Well, I believe that reading question number 2 made it clear how the jury would have answered question number 1. And so it wasn't necessary to go back to the jury. Certainly, if the then attorney for appellant had felt that there was some real lack of clarity in the decision, he could have made that request. Frankly, having tried the case, I don't think anyone was anything but clear on the import of that juror questionnaire. So then very briefly on the issue of the SMAC letter and the delay of the sale, Fred Esker, who was the purchaser of the business, made it very clear that it was the anonymous complaint filed in the summer of 2019, which we all know to have been the complaint that the evidence showed Kevin Barrup filed, that in fact did delay the sale. In fact, if you look at his entire testimony, which is part of the transcripts in the case, what he explained is that nobody was really concerned about the SMAC letter. Those issues had been resolved. And certainly he wasn't going to let that hold up the sale. What did cause a problem and a delay in the sale was this now second A&R complaint. Mr. Esker explained it just gave him a lot of concern about his decision to purchase the business. So I think his testimony, some of which was cited in our brief at page 5, and the remainder of which is part of the record in the case, makes clear that in fact it wasn't the SMAC letter that delayed the sale. It was the A&R complaint, the anonymous complaint, which we showed was filed by Kevin Barrup. So unless there are further questions, I am content to just rely on the briefs in this case, Your Honors.
Thank you. All right, thank you very much. How much time does the appellant have, please?
Appellant has 1 minute and 37 seconds remaining.
Counsel.
Thank you, Your Honors. So first of all, the 2019 complaint was anonymous. There was never any direct evidence, and I don't believe any circumstantial evidence to show that Kevin Barrup filed that complaint. It was basically speculation on the part of the jury. And secondly, that problem got addressed and cleaned up by September before the original closing date. And again, it's clear that what delayed the closing, regardless of what anybody said, was that the contract specifically provided that the SPAC letter from a 2009 cleanup that had never gotten properly documented had to come through. And as soon as that letter came through, they closed in December. So they're really reaching at straws and not really looking at what the evidence was, in fact. So the fact that, so it's pretty clear, given the undisputed facts of this case, that this anonymous complaint made in 2019 did not delay the closing. It was the need for the SPAC letter. Thank you, Your Honor.
Thank you very much. Thank you both. Please